rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time and date scheduled for oral argument in our cause number CV24 0214, Perez versus Patterson. These proceedings will be audio and live streamed recordings, so please introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to argue. If you'd like to reserve any portion of that time for rebuttal, we'll leave that up to you. This morning we met, discussed the case, we've read the briefs, discussed this case with each other, we're familiar with the facts. Please bear that in mind during your presentation. At this point, counsel, if you're ready.
Good morning, Your Honors. My name is Robert Gregory, and I am counsel for Plaintiff Lawrence Perez. We are here today for the second time. This is the second time we've been before this court in this matter, which was filed a little over 2 years ago. The matter's never progressed beyond briefing and appeals, and we're here today on a second appeal related to the issue of whether or not there was a duty of care owed by the superintendent of the St. John's High School to the plaintiff.
Counsel, I'd like to make sure that we're all on the same page. You're requesting, and the way I read your complaint in this matter as it relates to Mr. Patterson, is that you are suing him for his negligence in conducting the affairs as a superintendent, but you think he should be personally liable for those actions.
Yes, Your Honor. In both his administrative capacity as superintendent and personally, when he assumed the position as superintendent and had the duties.
Why would he personally have a duty, independent of being the superintendent? Are you saying there's something, let's say he's not the superintendent, he would have some sort of duty?
Well, when I say personally, I mean that he, the person, as opposed to an employee of the school board. I'm not saying that he would.
I don't see the difference. He's either personally responsible, as in he was driving his car to work and he hit somebody. He's personally responsible. Yeah. All of your allegations in the complaint allege to what he did as an employee. That's the only obligations, but you say he should be personally liable for that.
Let me backtrack a little bit so that we don't, I don't want this to go down the wrong way. The derivation of his duties comes solely in his capacity as superintendent, as an employee of the school district.
He was negligent, and so I can wrap my head around it. He was negligent in how he performed his duties as a superintendent. Ergo, he should be personally liable. If you get a judgment against him, you are going to collect against him and nobody else.
I believe that would be correct. We're not
This
here.
is not a trick question. I just need to make sure I understand what you're arguing.
And that is correct. Whether he has any type of an indemnification agreement with the school district is between him and the school district.
Okay, I got it. Now, next question. If we're looking at somebody who his actions are as an employee, a public employee, which he is, a public officer, then why doesn't he have qualified immunity?
Well, in this case, it's because he assumed a specific duty of care, to exercise reasonable care to protect invitees, which plaintiff was.
Okay, that doesn't answer my question. Why doesn't he have qualified immunity for his discretionary calls?
He didn't assume any new duties. That's part of his duties.
That's his job.
As the superintendent. So if you have qualified immunity for negligent acts in conducting your job, where do you go from there?
Well, qualified immunity doesn't eliminate the possibility for a negligent claim to arise. It just
Yes, it
heightens the
does.
burden.
It's negligence. You have to allege gross negligence. And I don't see anything in this complaint where you have alleged either facts or a statement that gives rise to a claim for gross negligence.
And that is correct, Your Honor. And that's something that the parties talked about early on before we got going down the road of briefing, is if this court were to rule that the only way that plaintiff could allege his complaint would be to allege gross negligence, then we would ask the court for leave to be able to amend the complaint to do so. We do believe that the grounds exist to appropriately allege gross negligence. We believe, based on statements that were made available to plaintiff.
But counsel, let's stop right there. We can't grant you leave to amend your complaint. As your complaint sits here today, have you alleged gross negligence, yes or no?
No.
All right.
So what I would like to do is just lay out why I believe that the superintendent is liable in negligence. And
Well, I'm really struggling with why this isn't just a qualified immunity towards simple negligence. And so if you could explain to us what facts that are either in the complaint or in response to the motion to dismiss that would give rise to a claim for gross negligence.
Thank you, Your Honor. The facts are there in the complaint. And let me backtrack and give a little bit of facts about the case. Mr. Perez was a visitor to a high school football game. He was 76 years old at the time. There was a standing body of water upon entrance into the stadium. There were no warning signs. That body of water, we came to learn later, after filing the complaint, or before filing the complaint, had been there for some time. Other persons had been injured in that same body of water. So there's no question that the school was aware that it existed.
Well, that's a little bit of a jump. So other people were injured, but at what point was the school made aware that someone was injured? The fact that two people were injured doesn't necessarily put the school on notice. What you expect the superintendent to have known about it for? What are the facts that suggest he was aware and did nothing about it?
Well, we don't have access to those facts. We don't have access to school records that would inform us as to prior accidents and what actions the school took, what the school knew, how they responded to that knowledge. We don't have those facts. In fact, we couldn't acquire those facts without discovery. But we do know, and we've alleged it in the complaint, that there were prior accidents in the same location and injuries that were known to students and teachers.
Serious injuries? I mean, the fact that I may have stumbled and fell and had a scrape is a lot different. And you don't get me wrong, I'm not downplaying the injury that happened in this case. But it's against the school or the district, and for whatever reason, apparently it wasn't even your client's fault, they weren't properly served. And so they're out of it. So now we're going to what actions or inactions did the superintendent take or not take that would give rise to a claim for gross negligence?
He failed, well, there's several, if I may. One, he failed to make any kind of warnings to visitors to the school, invitees.
Well, that presumes that he knew that this was going on. He personally knew it was going on.
It's his duty to know, as made clear in the policies adopted by the school. It's not, the burden at this point is not to prove that he knew.
But that goes to the question. I mean, so a couple of people slipped. And again, understanding the injuries could be very serious in this case. But was there evidence that there were serious injuries or something more than somebody slipped once or twice in the same place? Was it based that same time, or just the puddle in the same place from months earlier? Or what was the evidence that gives rise to this particular person had knowledge and should have done something? apart from the property owner should know, but that's different than saying he's personally aware of and was grossly negligent for not doing something.
Again, it's beyond my capacity at this stage of proceedings to be able to allege facts and comply with Rule 11 that we know of who was injured, what injuries they sustained, what the school knew. That information, I am confident, is sealed, and that's strictly between the school and that injured party. That information I would seek to bring out during discovery, but obviously at this stage of proceedings I don't have that. I do know, however, because plaintiff was informed, and that's why we alleged, that in fact after this accident occurred and Mr. Perez was recuperating from his shoulder injury, teachers and students came to him and said that's the exact same spot where others have been injured. That's all we know at this point, and that's all we can allege. But we think that that's sufficient.
But again, is there anything in what you've done so far that would indicate the superintendent knew?
Well, if I may, Your Honor, I believe that knowledge is imputed to him. It's his duty.
No, it's for gross negligence. It's almost a conscious disregard. That's what the Arizona Supreme Court has said. And for it to be a conscious disregard, he has to have consciously been aware of it.
That's true, but I believe whether he consciously disregarded the knowledge of that standing body of water and the risk that it posed to others is a question of fact. And
Well, that's if there has to be an allegation that he knew, and if all you have is some other employees, if other employees know, then it makes sense that you could hold the district liable, the school liable. But I'm not sure how that gets you to the superintendent personally if there isn't some assertion that someone slipped earlier in that same spot and we told the superintendent and he did nothing.
yeah. If I may just lay out for the court what I think is the progression of why the superintendent is liable in his capacity as administrator.
And why would you need to go there? Typically, I mean, it seems like a good case against the district, and you don't need to figure out at what point which district employee was aware of it.
Yeah.
You've got a claim against the district, but why isn't your claim for failure to whoever didn't properly serve the district as opposed to going after someone personally without knowing whether that person had knowledge?
I'm sorry, why is the claim? I want to make sure I understand the question.
Well, it seems like you'd have a better claim against whatever the failure to serve. Obviously, you'd have to win the underlying case that you would have won.
Right.
But that seems different than, it seems like the case is against the district and not against someone without an allegation that this person had knowledge and deliberately did something or failed to do something to establish gross negligence, and you didn't allege gross negligence. So it seems like the wrong person is being charged here. Not charged, but
And that's not how we saw it when we filed the complaint. We believed that the policies adopted by the school delegated all authority for ensuring the safety of invitees to the superintendent.
Well, they can't delegate. Their ultimate responsibility is the landowner. And in Hogue versus City of Phoenix, we said even the City of Phoenix code that delegated authority, that gave employees their responsibilities, didn't mean that there was an independent duty for the employees absent gross negligence. So here, unless you allege gross negligence against Mr. Patterson, what would indicate that whatever he was doing in his capacity as superintendent, even if we assume that he was negligent, it seems to me we circle right back to, well, he has qualified immunity.
Well, you said one thing there that I just want to hit on and reserve my time for rebuttal, is that the ownership, who was the owner of the land or the so-called possessor of the land, is not the controlling factor here. And I know that's been alleged repeatedly throughout the briefing. It is who exercised control over the premises, this particular piece of land.
But the cases that talk about that are always going to the person who has ultimate control. And if it's been delegated to the superintendent presumably doesn't have authority to do something the district board doesn't want him to do. I didn't see any of the cases that suggested that the delegee, and again, going to just a duty absent gross negligence, the cases seem to focus on the property owner, the one who has ultimate authority over who comes and goes on the property.
In some cases, yes, but in other cases, not so. For example, the Arizona Supreme Court in 1980, in the case of Jessic v. Maricopa Community College District, the plaintiff in that case alleged that the dean of students and the security guard were responsible for an injury, as well as the school district, were responsible for an injury that occurred, well, actually a death that occurred on school grounds. The Supreme Court sent the case back to the Superior Court with the holding that the dean of students and the security guard did have an affirmative duty to exercise reasonable care. And in that case, nothing was said that gross negligence was required, simply that they had a duty.
Were they going to be personally responsible, or was ultimately the Maricopa County School District going to be responsible, and that the district can't give the potential liability to an employee? So if they were, in fact, didn't exercise ordinary care, then Maricopa County the school district would be liable.
I don't know the answer to that question, Your Honor, of whether the Jessic court, when it was sent back to the lower court, whether they looked to personal individual liability or liability under the umbrella of the school district. I don't know the answer to that.
Isn't it kind of respondeat superior? I mean, the superior here, the superior here. If they're not in the case, do you get personal liability?
They remained as defendants in the case for the Supreme Court. And though the defendant in that case sought to dismiss them personally, they were not dismissed. So I can only assume that when the case went back to the lower court, they remained as personal defendants. Your Honors, if I may, I'll take a break.
Thank you.
Good morning. Chris Welker on behalf of Defendant Kyle Patterson. This is a straightforward premises liability case as it pertains to an alleged injury, alleging a dangerous condition on the premises, on the property. It is fundamental under our jurisprudence that an invitee to a property is owed duties by the landowner or possessor of the land. There is no law in Arizona, no case law in Arizona or statute that makes a public employee personally liable for the condition of the public entity's land. Plaintiff didn't cite to any such law. We could not find any such case.
So are you arguing that your client had qualified immunity in that case? The exercise of discretion? Yes, your client.
Yes, in this case, Mr. Patterson does have qualified immunity as he is a mere employee of the public entity. As the court
Did you allege that in your answer as a defense?
We did allege all immunities within 12 ARS 12-820 through 12-826. Our answer did allege all those immunities.
Okay.
And as the court has pointed out, as a public employee, Mr. Patterson is entitled to qualified immunity unless plaintiff alleges gross negligence, and there has been no allegation of gross negligence against Mr. Patterson. There's been no allegation whatsoever of any affirmative conduct or any specific knowledge attributed to Mr. Patterson. Now, of course, that wasn't the basis for the trial court's decision, but of course this...
And this is the duty part. If we're looking at a special relationship or a statutory relationship to set forth the duty, don't we have to look at the legislative part of qualified immunity to indicate whether or not there was a duty as it relates to negligence?
I suppose the qualified immunity does go hand in hand with the duty question, Your Honor. And again, public employees enjoy qualified immunity unless they are grossly negligent, which has not been alleged here.
Is there a scenario where Mr. Patterson could be grossly negligent? Counsel talks about, well, this puddle's keeps coming up, or it's been there for a long time. Other people have been injured. At what point in time does Mr. Patterson have to take responsibility for all of these injuries?
Well, Your Honor, that does get to the heart of the duty question, and our position is in a premises liability action such as this, an individual employee, be it a public employee or a non-public employee, does not owe a personal duty to the public at large.
Okay, well, let me give you a hypothetical in that scenario. So let's say we're not talking about the puddle on the pathway, but we're actually talking about the bleachers. And let's say that there's been a study done on those bleachers that would indicate they're unsafe. And that study has been given personally to the superintendent, and he does nothing about it. People climb the bleachers and it collapses. That does seem to me to be grossly negligent.
And our position is the cause of action still lies against the public entity, the district.
And couldn't they also allege it against the employee
Not
for
personally.
gross negligence?
Not personally. I know of no case law that creates...
Isn't that the premise of qualified immunity? You get immunity for negligent acts, but if it's intentional or the gross negligence, then you don't get qualified immunity? I thought that was the basic premises.
That is the premise of qualified immunity. However, there is still a duty issue which may be nuanced but somewhat distinct from the immunity question. That is the immunity analysis. I don't know that the immunity analysis agrees with the duty analysis 100% of the time.
Can I ask another hypothetical? If this is just Safeway or some ex-grocery store, and the manager there is aware of a puddle. I mean, is there personal liability against the manager? There's no qualified immunity as a employee of store X. Can the store manager be held liable for gross negligence if he or she's been put on notice of a dangerous condition and doesn't do anything about it?
We have not found any case in Arizona that suggests that's the case.
But wouldn't that come more under respondeat superior? Someone does something that's grossly negligent, they're liable, and then their employer is also liable. But why would we want to say someone is not liable for doing something grossly negligent? What would be the policy reason for reaching that conclusion?
Well, again, it would go back to the duty analysis, and as the Supreme Court recently said in Dinsmore, quote, people do not generally have a duty to protect others from harm, end quote. The Supreme Court in Dinsmore...
Does a store manager who knows about a puddle that people keep slipping on, does he not have a duty to have someone mop up the puddle?
Not under our premises liability law as it's developed. The duty belongs to the landowner, possessor of the property, who has the exclusive possession of the property. I suppose the same hypothetical could be posed regarding a custodian or a clerk who knows of something. The potential defendants are limitless. And that is not our jurisprudence, that all employees of all businesses potentially bear personal liability if they become aware of something in the performance of their job duties. I'm not aware of any case in Arizona or elsewhere that says that. And that's why our case law, I believe, focuses on the landowner or possessor, the exclusive possessor of the property. The cases that plaintiff has cited and relies upon all deal with landlord-tenants who had exclusive control or possession of the property, the landlord or the tenant, or a contractor versus owner who had exclusive possession at the time of an injury. Was it the contractor, was it the owner? The duty applies to the landowner, and that's our jurisprudence.
Let's say there's a clerk at the store in my hypothetical who who sees someone taking a piece of gum and acting in their capacity as the manager comes and just beats them or shoots them. Are you saying there's no personal liability for, even though they're acting their responsibility at the store, but it's clearly not just a negligent act, but an intentional act? There's no liability for that person? I get that you would also go after the store. It's their employee. But I'm hard-pressed to say there's no possible liability against the clerk or whoever is shooting someone for taking a piece of gum.
I would agree with Your Honor. In that case, where we have an affirmative act, an affirmative intentional act to harm another, I believe the law is clear that individuals cannot engage in affirmative acts designed to harm another.
You're saying that's different than gross negligence?
Well, I'm saying that's different than premises liability, a condition on the property, a condition on the property itself. And that duty pertains specifically to the landowner and possessor. And I'm not aware of any other case that makes that duty or imposes that duty upon an employee. And in this case, there is a specific statute regarding control and management of the property. ARS 15-341A3 says specifically that the district's governing board, quote, shall manage and control the school property within its district, end quote. By law, it is the school district that has exclusive possession and control of the property, not its employees, not the superintendent, not any other employee. And then ARS 15-326 specifically provides that the governing board shall be sued in the district's name. So our statutes make clear the governing board controls and manages and has the exclusive right to control and manage its property. And the governing board shall be sued in the district's name. Again, no statute, no case law suggests that an employee, even a superintendent, has exclusive control and possession over its employer's property. Plaintiff is cited to the internal district policies and procedures. Those pertain, of course, to the superintendent's employment responsibilities to his employer. They do not create some new special relationship between the superintendent and the public at large. And again, that is what Dinsmore recently emphasized, quote, duties are based on special relationships or on relationships formed by public policy, end quote. Again, no case that I'm aware of that we have been able to find indicates that there is some special relationship when it comes to premises liability claims between an employee of a landowner or possessor and the general public at large, be it a public employer or a private employer. And you can imagine the consequences if that were the law. Any employee of any business could be sued personally and be personally liable if the allegation is the employee had some sort of employment duty over the premises to inspect the premises and knew something about the premises. Then any employee of any business could be sued in premises liability personally. And that is simply not the law in Arizona. Finally, plaintiff relies heavily on the DeBouche case. Again, that case is inapplicable. It dealt with as between a lessee and a sublessee who had the exclusive possession and control over the premises to be charged with premises liability. That did not involve in any respect an employee of a business owner, an employee of a public entity, did not, of course, involve qualified immunity in any regard. Again, all of plaintiff's cases analyze between a landlord and a tenant and an owner and a contractor, a lessee and a sublessee who has actual control and possession of the property, exclusive possession of the property. And that's why ARS 15-341A3 is critical, because it specifically vests in the governing board of the school district the obligation to manage and control the property. Finally, there can be, under our case law, there can be a duty from a specific undertaking, an affirmative act. In this case, there is no allegation that Mr. Patterson did anything affirmatively, took any specific act to harm plaintiff. He was simply sued personally because he's a public employee of this school district. And once again, he has qualified immunity. There's no allegation of gross negligence, and there is no case law that finds a duty on an employee of a landowner. For all these reasons, we would respectfully request that the court affirm the trial court. Thank you.
Thank you, counsel.
Your Honors, I want to just address the claim that was made that the appellees have pled qualified immunity. They have not. I want to address this issue of duty of care, and we've been talking about, is it the school board?
You're saying it was not in their answer? They didn't allege?
It's not in their answer, Your Honor. We've been talking about duty of care. Where is it with the school board, or is it the superintendent? Is it both, or is it none of them? And
Well, before you, because I think this is important, if they didn't allege it in their answer and we send it back, would that stop them from putting it in now? I mean, they could file a motion and say, hey, we have qualified immunity. Because in the original answer, they're in it for a penny and a pound with the school district.
we're 2+ years into, well, I say litigation, but really briefing.
Well, you asked us to send it back to amend the complaint to allege gross negligence, so, and why are we keep litigating if there is an actual claim of qualified immunity in this case?
And not once in the case, Your Honor, has it been alleged or invoked as a defense. Not in any briefing, in motions to dismiss.
And you have not once alleged gross negligence, because your claim is really against the district. I mean, that's what your claim is about. Your claim is about the district that your client went to a football game and on the district property slipped and fell and seriously injured.
Your Honor, I respectfully disagree that it's against the school district. And I say that respectfully because...
Well, you sued him. So if you don't think it was against the district, then I'd be questioning why you brought an action against him if you sued them.
Abundance of caution, Your Honor. But what, to me, in this case seems like...
You think you're going to get a recovery only against Mr. Patterson and not against the district?
If...
No, I mean, in the original suit, you thought that, Patterson's the real bad guy here. We're going only after Patterson, but we're throwing in the district just for an abundance of caution. That's what you just said.
Yes. Yes, Your Honor. We believe that the person who exercised control, after we reviewed all the case law, in fact...
And so when they got dismissed out, you realized, abundance of caution, be damned, we're just going to appeal it. And no, you appealed it. It was so important that you appealed it all the way to this court. We had to issue a decision.
Yes, Your Honor, because we believe that the superintendent is responsible. There is a duty of care hot potato here. Council cited 15-341 where it says that the board shall enforce and adopt policies. But then the board turns around and assigns to the superintendent. The superintendent assumes responsibility for the use of buildings and grounds.
Okay, that doesn't take away the responsibility of the board.
Correct.
And
if the board did do something negligent, it's against the district, not in their impersonal capacity as board members.
They could both be liable here. The fact that the school district is not here is a travesty of that we don't need to go back and touch on, but I think I'm out of time.
You are out of time.
Thank you, Your Honor.
Anything else? Anything else? All right. Well, we thank you both for your arguments and your briefing here today. We will take this matter under advisement, issue a written ruling in due course. At this point, we will take a recess to reset the courtroom for our next argument.